To shift gears and bring in a jury consultant to talk about one specific part of this motion. I'm going to tell you folks, because it really is blowing me away, that this court, Judge Burke, has denied Harvey Weinstein's request to have a jury consultant who happens to be a good standing member of the New York State Bar sit at the counsel table during the voir dire process. And also interesting, folks, is that a lot of jury consultants and some of the best in the country are not, in fact, lawyers. But this jury consultant that they mention in this motion sounds like he's a lawyer if he's a member of good standing in the New York Bar. But the court has denied his request to be seated during voir dire, which is arguably, a lot of lawyers will tell you, it's the most difficult, most significant part of the process. So let's discuss this and jury selection in general with jury consultant Mark Calzaretta, who's joining me now live from our New York studio right outside the courthouse. Mark, pleasure to have you here. Thank you so much.
Thanks for having me.
Mark, so I don't know if you got to hear, because this just happened, but there is this motion to recuse, and apparently Harvey Weinstein wanted to have a jury consultant sit at the table. Tell us about your experience as a jury consultant and your process. Do you often just work behind the scenes before the trial, or also during the trial, or something else?
So it's both. There's a lot of work that I do prior to the trial from a research perspective, and most jury consultants would do, especially in a case like this. So there'd be a research component, which would be going on pre-trial, and then certainly during the jury selection process as well, being present there, helping with the development of the questionnaire that was developed and being given out to the jurors in this case, and then sitting at the table with the team and picking the actual jury and working with the trial team and the lead trial lawyer to identify jurors, problematic jurors for each side's position, depending upon who I'm working for. So it is unusual. To go to your second question, which it's unusual, especially being that the jury consultant is a lawyer, to not be allowed to sit at counsel table to assist with the jury selection process.
And okay, are most jury consultants lawyers, or is it just half and half? It depends.
I would say most jury consultants are not lawyers. Most jury consultants have a background in some sort of social psychology, some sort of behavioral psychology. The majority of them do. Some might have a background in psychology and also have a JD, but would never practiced.
Sure.
To have a licensed lawyer who's also a jury consultant, the only issue sometimes with judges, and I've had this before, is that technically, only lawyers are supposed to sit at counsel table. However, there's so much support staff that generally goes into a trial, especially a trial like this, that there regularly it's allowed. And I've been in several hundred trials, and I've only had it happen one time where the judge did not want it.
Really?
Did not want me to sit there, but after communicating with the judge said, "Oh no, that's fine. You can sit there. It was not intended for the jury consultant." So it's unusual, especially when in this case, the fact that this jury consultant is a lawyer. It's unusual.
So several hundred cases, and basically you're always allowed to sit at the table, Mark?
Always. I mean, I'm a jury consultant, not just myself, but a jury consultant is a critical part of the team during jury selection.
Mark, I have...
if in many ways, go ahead.
I have several more questions for you, but I got to hit a break. Can you stick around with us?
Sure.
Thank you so much.
Of course.
Our coverage of both New York versus Weinstein and Ohio versus Groves continues at the top of the hour. It was day 2 of jury selection in a New York courtroom for movie mogul Harvey Weinstein. There are so many issues with picking the jury itself, plus the fact that now the defense has this motion to recuse the judge. And the defense is basically saying, hey, judge, you are not letting us pick the jury we want in the way we want to pick it. Let's talk about it. With me from our New York City studio, Mark Calzaretta, jury consultant, and Shania King, criminal defense attorney, who is in studio. And Mark, you know, Shania's a little upset today because she's used to being the most fashionable guest on my show, and then you show up and you got your pocket square and you know, matching blazer to glasses, and even the watch even matches. Shania, okay, you guys can duke it out after the show, but for right now, serious topic.
Okay.
And that is the Sixth Amendment, the right to counsel. And what the defense is saying, Mark, and we talked about this a little before the break, is that Weinstein is being denied the right to have his jury consultant at the table during voir dire. So it's not like during the whole trial, just during voir dire, number one. Number two, and you explained this to us before the break, that this is not an issue of whether someone's a lawyer or not a lawyer, because you said you're not a lawyer, but you've done it hundreds of times.
I have. 100%. Yeah, it's unusual. It's definitely unusual, and it kind of, I think it shows the tone of the courtroom. And certainly one of the things that you never want to do is get on the bad side of the judge, either side. So it shows, and just with what's gone on there in the courtroom so far, it certainly shows that there's a tone. It's tense in the courtroom. And you know, it's unusual for a judge to preclude the jury consultant from sitting there at counsel table. It certainly is.
Shania, I did not even know that it was this unusual, because you know, I only did court-appointed cases, so no one was going to appoint me a jury consultant. So I didn't know this was such a big issue. Mark is saying he's done it hundreds of times. He's never had a problem. What do you gauge of Harvey Weinstein's Sixth Amendment constitutional right to counsel being infringed upon now?
I absolutely agree with Mark. The United States Supreme Court has said we're entitled to adequate and meaningful representation, just not a warm body. If that's the case, why have lawyers go through, 9 years of schooling, pass a bar exam? You need adequate and meaningful representation. And having that jury consultant in real time at the table is going to be the best option available.
And then another issue is that, Mark, I want your experience with this, is that the judge is putting a time limit on the voir dire process. And essentially he's saying 15 minutes per 20 jurors. The defense has done the mathematical gymnastics to come up with the equation that means 45 seconds of questioning and answering per juror. Is that also infringing upon Mr. Weinstein's rights?
Well, it certainly is short. You know, I think that's a little bit unusual. Judges will put a time frame on it. Usually the sides will agree, you know, they'll work with the court, the judge will work with all the parties, come up with, you know, parameters for jury selection, go over the voir dire process. In a case like this, to have only 15 minutes per 20 jurors is short. Now, there is a questionnaire, you know, and it's a very detailed questionnaire. So they will have a lot of information on the jurors that they'll get back prior to the actual voir dire process, and that's the process where, you know, each lawyer is allowed to talk and speak with the jury. It's the first impressions that the jury will have of the lawyer, and they're very important. Voir dire is critical. You know, establishing a relationship with the jury and a rapport with the jury, and that takes some time. And 45 seconds doesn't leave a lot of time per juror to accomplish that.
Especially when, Shania, the accusations against Weinstein, although they're not part of this case, the overall accusations against this man start from the 1970s, and they span not only this country, but internationally as well. What do you think about the time limit?
I think it's absolutely ridiculous. Here we have a questionnaire, but I think Mark can agree, we can't gauge someone's beliefs off a questionnaire. You get the best feeling from a juror when you sit there and you ask them a question to their face, and that's the best reaction. And when you look at them and see how they react when you ask them a question.
They also, okay, so the defense has mentioned that in some cases, high-profile cases, they cite a lot of case law in their motion to recuse, and they talk about this idea of individual voir dire. Mark, do you think, and from your experience, is that something that you've seen that would be more appropriate for this type of high-profile trial?
So not necessarily just for a high-profile trial, but because of the subject matter here. When you're dealing with abuse, sexual abuse, individualized voir dire, at least for those related to those issues, related to experience, their personal experience for themselves, a family member, close friends, something like that. To have individualized voir dire about those types of very sensitive, and there are other issues too to cover that are sensitive that no one's wants to talk about in an open courtroom. There is a way to have that sort of bifurcated, if you will, where you can have a generalized conversation about a majority of the issues, questions, and then move into individualized voir dire for certain people or certain people that have a certain background or answer a particular question, especially related to abuse, let's say, or their experience with it, to then move into individualized voir dire for those issues. So I think in this case, to have it for all of the questions probably isn't the most efficient way to do it, but certainly to have a portion of it, of the voir dire, to be conducted for those particular potential jurors that have some sort of experience or need to talk to the court in a more private manner, I think that it's highly appropriate under the circumstances.
And you would agree with that, Shania, right? This is a sex crimes case, essentially, and individual voir dire would certainly be appropriate for this.
I absolutely agree.
Now, I want to before I have to let you both go, I do want to talk about this questionnaire. And Mark, did you get a chance to look at the questionnaire? And is there anything that you would have added or taken away from it?
Sure, yeah, I got a chance to look at it. It's pretty complete. There are a few questions maybe and areas that I would have touched on. One in particular, I probably would have asked them if they had experienced a significant loss or hardship in the past, say, 3 to 5 years for themselves or a family member or a close family friend. That type of question, if someone has that type of hardship, and by hardship it could be financial hardship like a bankruptcy, something of that nature, or has some other type of loss, like loss of a loved one, someone close to them. This is outside of the experience that they've had of any type of verbal, physical, or sexual abuse. That would be critically important for me, because those questions, and that question in particular, if a person has that type of experience and it's within about a 5-year window, and it's sort of critical, the timing there, all of the research and my research has showed that can be predictive of juror orientation. So in other words, someone who has experienced a loss is more likely to identify, in this case, with the victim. So that would be something that I would want to know if I was on the defense side.
That's really interesting. That's really interesting, Mark. But Chanel, it's like you said, this questionnaire, it's long, it's 14 pages, but it's not like me looking in your eyes and getting a reaction and also trying to gauge if you can be fair and impartial to my client if I'm the defense attorney.
I agree. For example, say you asked in a questionnaire, have you had an experience with a loved one who was raped?
Yes.
And you can say, my sister was raped. But if you were asked the question individually, you could say, my sister was raped, but I know she made it up because she was mad at her boyfriend at the time. And
Right.
that changes everything.
Oh, right, absolutely, and those type of questions are absolutely on here. And just for our folks at home who are watching, you can look at the juror questionnaire yourself. It is on our website, and I do want to thank both of you for joining in and talking about this jury questionnaire. It's a really important issue. And Mark Calzaretta, your last thoughts. How long do you think it's going to take for them to pick a jury?
I think it's going to be difficult. I think it's going to take a while.
What's
they're
a
at right
while,
now
Mark?
for-
I need a
they're
number.
At a 70%. A while? I mean, look, they're dismissing 70% of the jurors every single day, and they're only getting about 30-ish people per day to even answer the questionnaire. And then from there, they're going to cut people down from there. So if this kind of continues on, I mean, to take a week to do this, certainly that's on the table. Could it take longer? It depends how people answer this questionnaire. But they're excusing 70% of the jurors right off the bat every single day. So before you're going to get enough, a panel of, let's say, 90, let's just say 90 people answer this questionnaire, 100 people answer this questionnaire. Out of those, the hit rate for that could be 70%. So think about
wow,
it.
yeah.
It's just, this is going to take a while. This
All
is going
right.
to take a
Well,
while.
Mark Calzaretta, I hope you and your pocket square will come back and weigh in with your expertise as well. Thank you so much for joining us. Shania Kane, you're going to stay with me. More emotional testimony in the other trial that we're covering, Ohio versus Groves. That's right after this.
Tonight on Court TV.